So in this case, in Russo and Westpac Banking Corporation, Mr. Russo was a senior manager who was entitled to a $70,000 bonus each year of his employment on top of his salary. Just after the finish of Westpac's financial year in 2009, his position was made redundant, and Westpac claimed that he wasn't employed at the date of him being entitled to the bonus, and therefore he wasn't entitled to it at all. He brought proceedings against Westpac claiming that it had breached his contract of employment and the bank's redundancy policy, which had stated that he would have been entitled to the bonus. During proceedings, Westpac's manager was quite extensively cross-examined and admitted that he failed to follow the redundancy policy and had taken into consideration external factors which shouldn't have been considered. Mr. Russo also claimed that Westpac had engaged in misleading and deceptive conduct during his interview process, where they had said that he would be entitled to a bonus. Ultimately, Mr. Russo was forced to drop that together with his implied term of trust and confidence after this decision in Commonwealth Bank and Barker. Ultimately, the court decided that whilst the policy wasn't incorporated into his employment contract, it did determine what he was entitled to at redundancy. So the court awarded him $70,000 that he would have been entitled to had the process been carried out effectively.
I mean, I won't be surprised if this decision is appealed, because it appears to me that the Judge Lloyd Jones has relied on the sort of opportunity to participate type cases like Silverbrook, which are quite different in nature, where people have contracts that talk about bonus entitlements being based on certain things, and then that's never followed through with, and the person has lost the opportunity to achieve a bonus. In this case, the contract clearly stipulated that it was a discretionary issue, and there were a whole heap of policies and performance review type documents that the court went through in detail about how the bonus amount was come up with, the different achievement levels that one would have to reach. So I think it's quite different, and I don't necessarily think the judge has recognised that in this case.
So it's an extremely common thing to have in contracts of employment that discretionary bonuses are not paid if your employment ends when they become due. I'm pretty sure that Westpac will appeal it because it has such ramifications. It just depends on whether there's some finding of fact in relation to, that stands up in relation to whether in this particular case the amount he was going to get was a term of the contract. It's very hard to see how it could be, because you'd assume that Westpac has got experienced employment lawyers that would make sure that that wouldn't be the case.
A lot of the evidence turned on his latest performance review, and apparently there'd been some miscommunication. His manager had meant to give him a lower level ranking, which would have meant he wasn't necessarily entitled to the full bonus, was he still employed even, but had actually communicated that he was a high achiever still. So there was some significant issues there, but leaving that to one side, it does come back to the contract issue. And I think the judge in this case has made a bit of a big leap between, because it's a redundancy situation, sure it's not a part of the contract, but I'm just going to rely on the policies anyway.
Well, it's hard to see how the policies come in, if not through the contract. But again, it does look like one of these cases where, when he talks about the manager making extraordinary admissions, that one of the witnesses for the bank has really got offside with the judge, which is one of the factors that can determine. I think the judge
commented that they were arrogant and clearly took a dislike to the witness.
So, I mean, I think they will appeal. The only question is whether there's some finding of fact that the appeal court will find hard to overturn, or the federal court will find hard to overturn. It is also a lesson in terms of taking great care in relation to these incentive schemes, because inconsistent messages, even if you do have the most robust contract in the world that says you can do whatever you like, it's going to get you into hot water and potentially highly expensive litigation if you're giving inconsistent messages.
Yep.